ordering with such awareness has to be regarded as accepting that crime. The appellant also challenges the trial chamber's finding in relation to the actus reus and mens rea requirements for aiding and abetting. In this case, the trial chamber correctly followed the standards set out in the Furunja trial judgment in respect of the actus reus of aiding and abetting. In relation to the mens rea of an aider and abetter, the trial chamber held that in addition to knowledge that his acts assist the commission of the crime, the aider and abettor needs to have intended to provide assistance or, as a minimum, accepted that such assistance would be a possible and foreseeable consequence of his conduct. As stated in the Vasilievich appeal judgment, knowledge on the part of the aider and abettor that his acts assist in the commission of the principal perpetrator's crime suffices for the mens rea requirement of this mode of participation. In this respect, the trial chamber erred. The appeal chamber, therefore, finds that the trial chamber was correct in part and erred in part in setting out the legal requirements of aiding and abetting. However, the trial chamber did not hold the appellant responsible for aiding and abetting the crimes at issue. In addition, the appeal chamber considers that this form of participation was insufficiently litigated on appeal and not fairly encompassed by the Second Amended Indictment, and the appeal chamber therefore declines to consider this form of participation any further. As to Article 7.3, the appellant submits that the trial chamber erred in its interpretation of the knowledge requirement under that article. In respect of this requirement for commanders, the trial chamber holds that their role obliges them to be constantly informed of the way in which their subordinates carry out the tasks entrusted them and to take the necessary measures for this purpose. The appeal chamber considers that the Celibici appeal judgment has settled this issue and that a superior will be criminally responsible under the principle of superior responsibility only if information was available to him which would have put him on notice of offenses committed by subordinates. However, neglect of the duty to acquire such knowledge is not a separate offense under 7.3. A superior will not, therefore, be liable for such failures, but only for failing to take necessary and reasonable measures to prevent or to punish. The trial judgment's interpretation of the standard is not consistent with the jurisprudence of the appeal chamber in this regard and is corrected accordingly. The appellant was charged in the indictment under both Article 7.1 and Article 7.3 of the statute. From the conclusions drawn by the trial chamber in relation to certain events and in view of the disposition, it is clear that the trial chamber considered the merits of the case in terms of both Article 7.1 and Article 7.3 in relation to those events. But the appeal chamber has to express concern at the disposition of the trial judgment, wherein the trial chamber, having found the appellant guilty for ordering persecutions and for having committed other offenses on the basis of the same factual findings, further finds that in any event, as a commander, he failed to take the necessary and reasonable measures which would have prevented these crimes or led to the perpetrators thereof to being punished. This statement, which refers to Article 7.3 responsibility, reveals a case of concurrent conviction pursuant to Article 7.1 and Article 7.3 of the statute, in contradiction with the correct view expressed in paragraph 337 of the trial judgments, which reads, I quote, "It would be illogical to hold a commander criminally responsible for planning, instigating, or ordering the commission of crimes at the same time reproach him for not preventing or punishing them. However, as submitted by the prosecution, the failure to punish past crimes, which entails a commander's responsibility under Article 7.3, may, pursuant to Article 7.1 and subject to the fulfillment of the respective mens rea and actus reus requirements, also be the basis for his liability for either aiding and abetting or instigating the commission of further crimes." Unquote. The provisions of Article 7.1 and Article 7.3 of the Statute connote distinct categories of criminal responsibility. It is not appropriate to convict under both Article 7.1 and Article 7.3 of the Statute in relation to a particular count. Where both Article 7.1 and Article 7.3 responsibility are alleged under the same count, and where the legal requirements pertaining to both of these heads of responsibilities are met, a trial chamber should enter a conviction on the basis of Article 7.1 only, and consider the accused's superior position as an aggravating factor in sentencing. The appeal chamber therefore considers that the concurrent conviction pursuant to Article 7.1 and Article 7.3 of the statute in relation to the same counts based on the same facts as reflected in the disposition of the trial judgment constitutes a legal error invalidating the trial judgment in this regard. Furthermore, where the trial chamber did not make any factual findings on the basis of Article 7.3 of the statute, the appeal chamber has not considered this mode of responsibility, notwithstanding the sweeping statement concerning Article 7.3 responsibility contained in the disposition of the trial judgment. The second ground concerns alleged errors of law concerning Article 5 of the statute. The appellant submits that the trial chamber erred in several significant respects in construing and applying the legal requirements of Article 5, crimes against humanity. This ground of appeal has several elements. As to the requirement of a widespread or systematic attack, the appeal chamber has considered the trial chamber's articulation of this element of crimes against humanity and concludes that the trial chamber was correct in its analysis of this element. As to the requirement that the attack be directed against a civilian population, the relevant requirement was set out in the Kunarac appeal judgment. Both the status of the victim as a civilian and the scale on which the attack is committed or the level of organization involved characterize a crime against humanity. In determining the scope of the term civilian population, the appeal chamber considers that the presence within a population of members of resistance groups or former combatants who have laid down their arms does not alter its civilian characteristic. The trial chamber was correct in this regard. However, the trial chamber erred in part in its characterization of the civilian population and of civilians under Article 5 when it stated that the specific situation of the victim at the time the crimes were committed must be taken into account in determining his standing as a civilian. The victim's specific situation at the time the crimes are committed may not determine his civilian or non-civilian status. If he is indeed a member of an armed organization, the fact that he is not armed or in combat at the time of the commission of crimes does not accord him civilian status. As to the requirement that the acts of the accused and the attack itself must have been committed in pursuance to a pre-existing criminal policy or plan, the appeal chamber reiterates what was stated in Kunarac, that a plan or policy is not a legal element of a crime against humanity, though it may be evidentially relevant in proving that an attack was directed against a civilian population and that it was widespread or systematic. The trial chamber was not clear on this point of law. As to the requirement that the accused has knowledge that his acts form part of a broader criminal attack, the appeal chamber considers that the mens rea of crimes against humanity is satisfied when the accused has the requisite intent to commit the underlying offenses with which he is charged, and when he knows that there is an attack on the civilian population and also knows that his acts comprise part of that attack. As set out in the appeal judgment, the appeal chamber finds that the trial chamber erred in part in its articulation of the mens rea applicable to crimes against humanity. As to the actus reus element of persecutions as a crimes against humanity, the appeal chamber considers that persecutions as a crimes against humanity has already been defined in the case law of the International Tribunal. The trial judgment, however, sets forth a definition of persecutions that characterizes the actus reus as encompassing infringements upon fundamental human rights. This analysis constituted a failure to assess whether the underlying acts amount to persecutions as a crimes against humanity in international customary law. The trial chamber erred in this regard. As set out in the appeal judgment, the appeal chamber considered each of the types of conduct considered by the trial chamber. They were killing or murder and causing serious injury, destruction and plunder of property, deportation, forcible transfer and forcible displacement, inhuman treatment of civilians, and attacks on cities, towns, and villages. In conclusion, the appeal chamber considers that it is evident from the trial chamber's analysis of the applicable law on persecutions that it did not consider the requirement that acts of persecutions must be of an equal gravity or severity as the other acts enumerated under Article 5 of the Statute. The appeal chamber notes that it is not enough that the underlying acts be perpetrated with a discriminatory intent, and the trial chamber erred in this regard. As to the mens rea element of persecutions as a crimes against humanity, the appeal chamber stresses that there is no requirement in law that the actor possess a persecutory intent over and above a discriminatory intent for persecution. The appeal chamber also emphasizes that the mens rea of a perpetrator carrying out acts of persecutions requires evidence of a specific intent to discriminate on political, racial, or religious grounds. The trial chamber was correct when it held that the mens rea for persecutions is the specific intent to cause injury to a human being because he belongs to a particular community or group. Second, the appeal chamber is aware that in making its factual findings relating to the ordering of crimes under Article 7.1 of the Statute, the trial chamber frequently employed language such as took the risk or deliberately ran the risk. The appeal chamber has articulated above, as I mentioned, the mens rea applicable to ordering a crime in the absence of direct intent. Thus, an individual who orders an act with the awareness of a substantial likelihood that persecutions as a crimes against humanity will be committed in the execution of the order may be liable under Article 7.1 for the crime of persecutions. Ordering with such awareness has to be regarded as accepting the crime. The next ground concerns alleged errors of law in application of Article 2 of the Statute. The offenses covered by Article 2 of the Statute must be committed against persons as property protected under the provisions of the Geneva Conventions. Article 4.1 of Geneva Convention 4 defines protected persons as those who, at a given moment and in any manner whatsoever, find themselves in case of a conflict or occupation in the hands of a party to the conflict or occupying power of which they are not nationals. The Tadić Appeal Chamber concluded that this provision is directed to the protection of civilians to the maximum extent possible, and that even if, in the circumstances of that case, the perpetrators and the victims were to be regarded as possessing the same nationality, Article 4 would still be applicable. Applying the same principles in the context of the conflict between the Bosnian Croats and the Bosnian Muslims, the Appeals Chamber in Aleksovski reasoned that since the conflict was international by reason of Croatia's participation, it would follow that the Bosnian Muslim victims were in the hands of a party to the conflict, Croatia, of which they were not nationals, and that therefore Article 4 of Geneva Convention 4 was applicable. The Appeal Chamber in Celebici reaffirmed and elaborated upon these principles when considering their implications for Bosnian Serbs held by Muslims. The Appeal Chamber finds that there is no merit in the appellant's assertion that, under the allegiance test, Bosnian Croats would not qualify as protected vis-à-vis Bosnian Muslim captors. The Appeal Chamber finds that there is no merit in the appellant's assertion that the present case can be distinguished from the Tadić and Celebici cases on the basis that the Bosnian Serbs, unlike the Bosnian Croats, were attempting to secede from Bosnia-Herzegovina. Arguments that the victims should be excluded from the status of protected persons according to a strict construction of the language of Article 4 of Geneva Convention 4 have already been rejected by the Appeal Chamber. The Appeal Chamber is satisfied, therefore, that the principle of legality has not been violated in this case. The Appeal Chamber sees no error in the Trial Chamber's determination in this respect. The appellant further submits that the protected persons requirement is based upon Article 4.2 of Geneva Convention 4, which provides that national of a co-belligerent state shall not be regarded as protected persons while the state of which they are nationals has normal diplomatic representation in the state in whose hands they are. The Appeal Chamber considers that it is evident, both from the text of Article 4.2 of Geneva Convention 4 and the accompanying commentary, that for Article 4.2 to be relevant, it must be demonstrated first that the states were allies, and second, that they enjoyed effective and satisfactory diplomatic representation with each other. The states of Croatia and Bosnia-Herzegovina were engaged in a conflict against each other. This in itself establishes that they were not co-belligerents within the meaning of Article 4.2. These grounds of appeal, therefore, fails. The fourth ground concerns alleged errors concerning denial of due process of law. The appellant claims that he was unfairly denied his right to a fair trial under Article 21 of the Statute of the International Tribunal in two principal ways. First, he was tried and convicted on the basis of a fatally vague indictment. And two, the prosecution failed to meet its disclosure obligations with respect to exculpatory evidence under Article 68 of the rules. The appellant contends that this deprived him of the due process of law and materially prejudiced his ability to prepare and present his defense. First, on the vagueness of the indictment.